before your dreams can come true.
MES College Erumely, proposed PO Erumely, Kottayam, unaided arts and science college under the Muslim Educational Society, approved by Government of Kerala and affiliated to the Mahatma Gandhi University.
Okay.
ഞാൻ ആദ്യമായി കോളേജിൽ പോകുമ്പോൾ ഭാവിയെക്കുറിച്ചുള്ള ആശങ്ക പലതായിരുന്നു.
Welcome to the webinar on Introduction to Intellectual Property Rights and their importance in Indian context. Really, intellectual property rights are legal rights aimed at protecting the creations of the intellect and protect consumers and families, etc. Let's start the program by a prayer. Mrs. Jasila Hanifa is the co-founder of IPR cell. Let's welcome Mrs. Jasila for the welcome speech.
വാഴുന്നോരീശ്വരൻ തിരുനാമത്തിൽ നിഖില ലോകങ്ങൾക്കുമേകരക്ഷകനാകും അഖിലേശ്വരനല്ലയോ സകല സ്തുതിയും അഖിലേശ്വരനല്ലയോ സകല സ്തുതിയും പരമകാരുണ്യവാൻ കരുണാനിധിയേ വിധി പറയും ദിവസത്തിനേകാധിപനേ നിയതമാരാധിപ്പൂ ഞങ്ങളങ്ങയെ മാത്രം സതതം സഹായമായി തീർപ്പതും തിരുമുമ്പിൽ നയിക്കേണം ഞങ്ങളെ നേരായ മാർഗത്തിൽ നിന്നനുഗ്രഹപാത്രമായോർ തന്മാർഗത്തിൽ അങ്ങയാൽ കോപിക്കപ്പെട്ടോരുടെ വഴിയല്ല സന്മാർഗഭ്രഷ്ടർത്തൻ വഴിയിലുമല്ല ആലം ദയാലുവായി ദാക്ഷിണ്യശാലിയായി വാഴുന്നോരീശ്വരൻ തിരുനാമത്തിൽ നിഖില ലോകങ്ങൾക്കുമേകരക്ഷകനാകും അഖിലേശ്വരനല്ലയോ സകല സ്തുതിയും.
Mrs. Jasila Hanifa is the coordinator of IPR cell. Let's welcome Mrs. Jasila for the welcome speech. Over to you, Jasila.
Thank you, ma'am. A very good afternoon to all. A hearty welcome to the webinar conducted by IQSC and IPR cell of MES College Erumely. I am Jasila Hanifa, coordinator IPR cell. You know intellectual property rights are the right given to the person over the creations of their minds. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. MES College is really privileged to platform this webinar on IPR, an introduction to intellectual property rights and their importance in Indian context. Nowadays, it is quite essential to each and every one, not only academicians in every sector, but also the basic knowledge of the IPR is very important. Researchers especially should have thorough knowledge about the various aspects of intellectual property rights, because nowadays so many illegal things are happening in this area. As a coordinator, I am very happy to have the opportunity to welcome you to this webinar. We have a vibrant leader and an efficient administrator as the pivot of this institution. It is none other than our respected principal Mahin MN. Sir, with great pride and pleasure, I welcome you to this function.
Thank you.
Today, we have an excellent resource person for interacting us with the various aspects of IPR, Dr. Bismi Gopalakrishnan, Dean, Faculty of Law, Professor and Head of School of Indian Legal Thought, Mahatma Gandhi University, Kottayam. She has been giving extensive lectures about IPR and related aspects. On behalf of IQAC and IPR cell of MES College Erumely, I cordially welcome Dr. Bismi Gopalakrishnan to this webinar. Nothing is possible without able action. I welcome the eminent personality, coordinator, IQAC and Vice Principal, Professor Rema Devi to this function. Well begun is half done. We have with us an agile person as our Vice Principal, Academic and Training, Mr. Jidesh KS. He has been contributing his abilities for conducting so many webinars throughout this year. I cordially welcome you, sir, to this function. I extend hearty welcome to Mrs. Sheba Ma'am, the student dean of our college, to this function. Next, I welcome Kavita Ma'am, CDC director of our college, who is always there for us with her warm support. The success of this webinar truly depends on the able and technical support given by Mr. Sabjan Yusuf, IT Director of our college. I welcome you to, sir, to this function. Participants are the key factor behind the success of every webinar. I heartily welcome all the faculties from other institutions, students from other institutions, our college students and my dear colleagues to this webinar. I also welcome all the members of MES family to this webinar. Once again, I extend a hearty welcome to one and all to this session. Thank you very much.
Thank you, madam. May I request Mrs. Demadevi, a Vice Principal and IQAC Coordinator, for an introductory address. Over to you, madam.
Thank you, Shiba. Is it audible?
Yeah.
Good afternoon, all. As the IQAC coordinator, I am very happy and proud that a lot of events are organized in association with various departments, clubs, and forums of our college. As you all know, the mission of IQAC is the overall development of the institution. For this, we are introducing many programs for curriculum enrichment and student support, like SOYM courses, certificate courses, bridge courses, etc. In these pandemic situations, we have been conducting a number of webinars, competitions, and quiz programs. Today, we are conducting a webinar on IPR, and we are fortunate enough to get an eminent personality like Dr. Bismi Gopalakrishnan, Dean and Head of the School of Indian Legal Thoughts, MD University. To know the rights of a person on his creation is the need of the hour. Everyone uses the creation of others in this today's context, and we share and modify intellectual creations of others. So, we are conducting this national webinar to know more about what are the rights of the writer and what are the rights of the user. We hope this will be an useful session to all of us. Have a wonderful session. Thank you. Thank you all.
Thank you, madam. May I request our beloved principal Mahanaman sir for the presidential address.
Okay, thank you. Good evening, all. I am happy to present with you this evening in connection with the webinar based on the topic An Introduction to Intellectual Property Rights and Their Importance in Indian Context, conducted by IQAC and the IPR cell of our college. We have already conducted 2 international and 22 national webinars on different topics during the period of COVID-19. I feel proud to say that our college is ready to cooperate with the UGC in its efforts to overcome the new challenges faced in the field of higher education. An IPR cell formed in this institution on November 3rd, 2020, with the objectives to conduct seminars, workshops on intellectual property rights to create awareness among the students and teachers. Promotion to create awareness, promotion of startup ventures and ED club activities to instigate an innovation ecosystem in the campus, provide legal supports to the inventor to safeguard their intellectual property. I wish all success for the webinar and congratulates the organizers, Mrs. Rava Devi Madam, Vice Principal and Coordinator IPAC, Mr. Jidesh K.S. Vice Principal, Mrs. Kavita P.D., Director CDC, Mrs. Shiva Mikhail, Dean of Students Welfare, and Mrs. Sabjan Yusuf, IT Cell Director, Mrs. Jasila Hanifa, Coordinator IPR Cell, and also express my deep gratitude to Dr. Bismi Gopalakrishnan Madam, Member, Syndicate MG University, Dean of Faculty of Law, and also Head of Indian Legal Thought, MG University, Kottayam, for arranging the class, for conducting the webinar, and also for being present here to inaugurate the function. Thank you. Thank you.
Thank you, sir. On behalf of all of us present here, I request Jidesh Kaiser, Vice Principal of Academics and Training, to introduce our resource person to all of us present here. Over to you, sir.
Thank you, ma'am. Good afternoon, all. Today, I'm very happy to address and also introduce an eminent personality, Dr. Bismi Gopalakrishnan, Dean, Faculty of Law, Head of School of Indian Legal Thought, Mahatma Gandhi University, Kottayam. She presently is Syndicate Member, Mahatma Gandhi University. Have a good academic wisdom in particularly the specialization areas healthcare, laws, intellectual property rights, and public laws. Had graded 9 PhDs and ended 3 MPhils. So we are blessed with the presence of an eminent personality, Dr. Bismi Gopalakrishnan. I welcome Professor Dr. Bismi Gopalakrishnan for taking the session on intellectual property rights. Thank you, ma'am.
Thank you, sir, for the valuable information. Before we start the webinar, I request all of the participants, please cooperate with us. Your link for certificates will be given by 4 o'clock today, and you may fill it and send it before 5 o'clock. Wish you a happy and successful seminar. On behalf of all of us present here, I once again welcome Dr. Bismi Gopalakrishnan for starting the presentation. Over to you, madam.
On and off. I think I'm audible. Is it?
Yeah, Audible, madam. Travel.
I'm very happy to be. I'm very happy. I'm reaching my quarters, no issues. So I've already reached Kottayam. So I'm very happy to be a part of the MES Family Initiative. Because I've been listening to the introductory notes. I understand that this particular webinar is being hosted by IQAC of MES Family and IPRC. Well, actually, I should give a big round of applause for this initiative because you are conducting, the family is conducting the webinar on the right time. This is the right time to conduct an IPR webinar because every one of us are facing a pandemic, the COVID-19 pandemic, and every day we are looking, our eyes are glued to the television, we are watching the news, we are just gluing our eyes to the Facebook or the social media and just panically waiting for the magical drug that will act as a barrier, that will contain, that will have the power to stop this particular pandemic or at least control the pandemic that we are facing. So we are talking about we are in the right stage of innovation. We are trying to innovate a new drug. We are trying to develop a new drug which will save the lives of millions of people across the world. So the principal of this esteemed institution, the vice principal, the student dean, the director of IQAC, and the coordinator of IPR cell, you have done a yeoman service as far as conducting the seminar, the webinar, because this is exactly the time when you should conduct the webinar on IPR. Because every one of the scientists around us, around the world, every one of us, we are thinking about inventing a new drug. So in the world, it is very similar. It relates to IPR because it falls within the ambit of patents. So it's not only patents, but you have different IPRs, sets of IPRs. So when you conduct the right webinar, at the right time, you will have the fruits of it. So I congratulate Honorable Principal, Vice Principal, the Director of IQAC and the IPR Coordinator for organizing this webinar on IPR. And I'm also thankful to the participants of this webinar because our participation definitely in programs like this, it will trigger the quest of thought and ideas in you. It will trigger definitely questions in you, and again, maybe you will also be a part of this noble venture of inventing new patents, maybe getting new copyrights, drafting new trademarks, protecting the geographical indications, all in etc. So I think with this introductory note, I think I can start my PPT. Am I right, ma'am? Or can I share the PPT now? Or ma'am, can you hear me? Ma'am, can you hear me? Ma'am, do you want me to share the PPT now?
Yes, yes.
Okay.
Yes, ma'am.
Okay.
അതെ.
Correct.
ഹലോ. ആ ആ നമ്മളിപ്പോ കോട്ടയം എത്തി. ആ. എവിടെയാണ്?
Can you see my slides?
Yes, ma'am. Yes,
Jessila
ma'am.
ma'am?
Yes, ma'am.
Okay. Perfect. So, basically, when we talk of IPR, we're talking about innovations,
മാഡം ഇപ്പൊ മീറ്റിംഗിലാണ്.
rather creations of mind. What is creation? Every one of us have a very powerful mind, a very powerful brain. You know, very often we talk of computers, we talk of supercomputers, we talk of iPhones and gadgets. But we forget that our mind, our brain is also equivalent to or more powerful than all these gadgets. So creations comes from our mind. Intellectual property, it is from our intellect. It is from our mind that this IPR steps into. So there is a myth that IPR it belongs only to a few persons. Each one of us can be the owners of IPR. Maybe we can invent a new drug and we can take a patent on that. Maybe we can write a poem or we can produce a film. We can take copyright on that. We can symbol, just like the Coca-Cola symbol or
4-4-8.
we can create just like the Coca-Cola Coke symbol or the Pepsi symbol. Or again, we can also think of inventing a flavor like the Coke that you sip. Each one of us is that power. Each one of us has that brain, through which we can talk of innovations. We can talk of creativity. So creation, innovation, it always relates to IPR. So the only thing is that what happens in IPR is that look, this is what I was talking about. Every one of us, I was also wearing a mask because I was traveling from Trivandrum to Kottayam. So every one of us is we are using gloves and masks so that we try to shield ourselves from this particular coronavirus. So this mask is, it's a peculiar mask, isn't it? And what is the peculiarity of this mask? It is evident, the picture shows it's evident because the cotton mask that which we use regularly nowadays, that is the four that which we are familiar with, or the N95 mask, what iron it and then we just reuse. When this particular mask, the Professor Yar of the Faculty of Material Science, reusable face mask. Heat. Okay, normally what we use is that we wash, we iron it, isn't it? So everyone they're trying to innovate in the mask. So what this professor did was that he invented a mask. He thought that look, there must be a new manner in which you must disinfect the particular mask, and you can use heat to disinfect this particular mask. And again, he also thought this mask must be reusable. And what he did was that he used a technology so that the inner layers of the mask is he used carbon fibers, and the disinfection process occurs when the layer is heated using a low current source. We can even use the mobile phone charger for this particular to disinfect this mask. So what I was trying to point out is that, look, we use cotton mask, but we have scientists across the world, like Professor N. Lee's research group, who is trying to create something new out of the mask. Okay, and so what he has created, he has created a mask so that, look, the mask, by using a small electronic mobile phone charger, by the low current of the mobile phone charger itself, you can disinfect that particular mask and you can reuse it. And this is on the process of he has filed the patent for this particular product. So products like this, any one of us, the students who are listening to this particular webinar, look, any one of us can think of this particular innovation. The only thing is that, we must think. So those people who think, they bring about new products, new processes, new things like this. Okay, so what matters more for IPR is that the first base knowledge that any one of us can be owners of IPR. The only thing is that we must make the best use of our brain. Now again, this is sort of another mask which has also gone for patents. So this is a mask which has taken with sensors. The sensors are fitted into the mask, and again, the professor who has invented this particular mask, he has gone for patent of this particular mask. So again, this is also another mask where, where again we have filed a patent. So what I was trying to tell you is that, look, whenever we think of new products or new creativity, like, the poem or a film or a picture or a photography or a new musical note, everything is new, everything is novel, and then you will have the IPR that is being attached to it. So these are different forms of the models of the products that many invented, and they went for the different models of IPR, especially these are the patent models. So maybe whether it is a GPS system or whether it is the modern manner in which the armor in which you can go for a protection, or even the simple clip that we use daily. This is also a patented product. So when this particular product was being launched for a patent, what happened was that it was out of the person. Out of this particular product, he made it and he took patent on it. So it may be simple, it may be complicated, like a drug which we are trying to launch, which has the capacity to stop the coronavirus. It may be complicated products like that, or it may be simple products like this. But whatever comes from our intellect or from our thinking capacity or from our brain. So it may be the penicillin, it may be the plant medicines, it may be the semiconductor nanotechnology, it may be the rDNA drugs, or the countless discoveries and innovations which actually do human service to the humanity. And, it brings a lot of technological progress. And all these new novel creativity falls into the group of intellectual property rights. So what is this? I've been using this word innovation. What is this innovation? Actually, the innovation, it starts with an idea. I told you, we have always seen a mask. This is a mask that I'm wearing when webinar. This particular, the thought process came, what all can be done in this particular mask. And so it starts from an idea, it starts from evaluation, it starts from thinking process. And again, you do a lot of research, you do development, you put in money into that particular research if it is a very big project. And then once a product has been it has been materialized, you talk of manufacturing that particular product, you think of producing that particular product, you think of marketing the product, you think of selling the product, you think of using the product. So all these steps, it contains the touches of IPR in different formats. So creativity is there and innovation is there. Creativity means the ability to make something into existence. You have never thought of that, but that is creativity. You bring in something new, you bring in a new solution, you bring in a new method or a device or a new artistic object or form. That is creativity. And innovation means within that particular introduction, you have introduced something new, and into that, you combine a new idea, method, or device. So creativity is nothing but idea and action. Action is creativity plus productivity. The base of IPRS. So I told you, invention definitely goes with the patents or the trade secrets. Then literally artistic creations, definitely we have the copyrights and the related rights. When we talk of financing, we talk of the patents, the product designs, we have the industrial designs and the trademarks, GIs, and commercializing and marketing, definitely again we have the traces of trademarks, GI, patents, copyrights, everything fusing together. This slide, what it reveals is that, IPR adds value to every stage of the value chain. IPR is there in every stage of value chain, from the creation to the innovation to putting a new, better, and cheaper product and service into the market. You can find that you can find different forms of IPR being attached into a particular product. So if you are an owner of IPR, either you can use it, you can license it. If you can say that I'm an owner of a product, I'm an owner of a patent or a copyright, you can use it on your own, or you can license it, you can give it to someone else, you can give the license to someone else, or you can sublease this to another person. So actually we are surrounded by intellectual property rights in all our daily life. The only thing is that we don't realize that our life is surrounded by IPR. Just look at this particular slide. Printing press, lightning rod, the bulb, the telephone, the 300 uses of peanuts, the basketball, fluorescent lighting. These are well-known inventors. iPhone, the www that which we often say, the radio guidance system. Once we never knew about this, but someone among us, invented this, launched it, and we have it. So all this, these are new products. It goes with the patents. So such products, this is nothing but intellectual property rights. And again, you have seen all these, isn't it? Coca-Cola, different forms of trademarks in different colors. Particular formats. Maybe if it is you, Yahoo, or Amazon, or Flipkart, whatever it is, it has its IPR touch in it. It may be in a form of a trademark, in the form of a copyright. So it is there. The only thing is that we don't realize that it is it's a different form of, it's a variant of IPR that we're talking about. So what are the different kinds of intellectual property rights? So intellectual property rights, there are the patents. First of all, we have the patents. Patents is one form of the intellectual property rights. Patents means it is a new product. Any product, I told you, coronavirus, the drug, it is a new drug. So that, it falls within the IPR called patents. Okay, then you have the copyrights. Okay, copyrights and related rights. Copyrights means whatever, if you have written a poem, if you have written, if you have produced, if you have portrayed, if you have taken a picture, if you have taken a photograph, that falls within copyright. Your dance performances, your musical performances, it falls within the realm of copyright. Okay, so patents, copyrights, then trademarks. Trademarks, for example, the Coca-Cola design that we have, or the McDonald design, I am loving it, or the TM, the orange. All these shows the identity of the brand that we're talking about. The identity. So maybe if it is Sony Vaio, or if it is Dell, or even the iPhone, the Apple, or the Samsung, whatever it is, they will have a picture or a writing, or even the word Microsoft. Have you just gone through the phrase Microsoft? Microsoft. Even the writing is of unique nature. So that is the trademark which depicts the origin of that particular product. And again, it also assures quality of that particular product. So I told you patents, copyrights, and again you have the trademarks. So 3 IPRs. The list is not over. You have the trade secrets. Now, what is trade secrets? Trade secrets means, I told you, the recipe which we still don't know. When we taste Coke or Pepsi, we say it's very, very tasty. Even McDonald's, it's very tasty. But what makes it tasty, we don't know. It's safe. It is, it's a secret, and that is the trade secret IPR. Geographical indications. Teachers, they might use saris which have embroideries of Kanchipuram or Pochambal saris. You have different types of products. For example, apple of different variety apples. You have different with oranges. You have different green tea. You have coffee. All of this, it relates to one particular environment or climate. So it refers. It is nothing but the geographical indications, which is Indian and IPR. Then layout, and here I have shown Kolhapuri chapels as an example of geographical indications. Then layout designs of semiconductor ICs. So here again, what happens is that this is also the IPR placement. Banana crops, and then you bring out a variety which is very short. The banana is very short, and the coconut is very short. Yield within the stipulated maybe 6 months or 3 months. So you talk of varieties, and again that is also plant varieties. That is also a form of IPR. So patents, trademarks, copyrights, trade secrets, geographical indications, then layout designs of semiconductors, ICs, then industrial designs. Industrial designs, the shape of a particular product. It comes with an IP. So all these are different forms of intellectual property rights. So actually we started with three IPRs, that is the patents, the copyrights and the trademarks. Later, and it was originally called the industrial property, and later, what happened was that this list was it was enlarged, and more IPRs was filled into the bandwagon of IPR box. So, actually, who created this? We, the people. We began to increase, we began to create more and more IPRs, and we introduced IPRs. So, the list, it was enlarged from the three. Again, patents, copyrights, and trademarks. It was enhanced, the list was enhanced, and now today we have patents, copyrights, trademarks, trade secrets, plant varieties, layout of designs, semiconductors, ICs, then industrial designs. Even you have right to reputation, you have the unfair competitions, all these, it has been introduced into the bandwagon of the bag of IPR. So actually, we the people decide that, more and more IPR comes into the forefront. So what is the concept of IPR? What is the concept of IPR? The concept of IPR is very simple. Very often we find that we know that our property house, we know one form of property, that is the tangible property, something which we can see, isn't it? House is our property, car is our property, the ornaments, these are our property. So vehicles are our property, isn't it? We know that this is our property. This is our property. So, the uniqueness of this property is that it is tangible. But what happens is that this is tangible. But what happens is that I've just Jasila ma'am, hello. Jasila ma'am? Jasila ma'am, just taking a break for 5 minutes. I'm just taking a break for 5 minutes because, ma'am, can you hear me?
Yes, yes.
Ma'am, just 5 minutes, I have to enter my quarters. Okay,
Okay.
just 5 minutes. I'm sorry for the inconvenience, but charger
ഇതിന്റെ
നിങ്ങൾ എനിക്ക് ഇത് വൈഫൈയിലോട്ട് ഷിഫ്റ്റ് ചെയ്യണം
ഞാൻ ആദ്യമായി കോളേജിൽ പോകുമ്പോൾ ഭാവിയെക്കുറിച്ചുള്ള ആശങ്ക പലതായിരുന്നു. എന്നാൽ സുന്ദരമായ ആ ക്യാമ്പസിലേക്ക് കയറി ചെല്ലുമ്പോൾ ഒരു ആത്മവിശ്വാസം എനിക്ക് ലഭിച്ചു. നല്ല സുഹൃത്തുക്കൾ, സംശയമകറ്റി വെളിച്ചം പകർന്നു തന്ന അധ്യാപകർ, പുതിയ ആശയങ്ങൾ നൽകിയ ലൈബ്രറി, ഏകാഗ്രതയും നല്ല ഓർമ്മകളും നൽകിയ ക്ലാസ് റൂമുകൾ, ഡിജിറ്റൽ ലോകത്തേക്ക് പറക്കാൻ പഠിപ്പിച്ച കമ്പ്യൂട്ടർ ലാബ്. അങ്ങനെ MES കോളേജ് എന്നെ ഉയരങ്ങളിലേക്ക് സ്വപ്നം കാണുവാൻ പഠിപ്പിച്ചു. ഇന്ന് ഞാൻ വളരെ ഹാപ്പിയാണ്. സ്വപ്നങ്ങളെ പിന്നിലാക്കി ഉയരങ്ങളിലേക്ക് ഞാൻ പറന്നുകൊണ്ടിരിക്കുന്നു. യു ഹാവ് ടു ഡ്രീം ബിഫോർ യുവർ ഡ്രീംസ് ക്യാൻ കം ട്രൂ.
MES College Erumely, proposed PO Erumely, Kottayam, unaided arts and science college under the Muslim Educational Society, approved by Government of Kerala and affiliated to the Mahatma Gandhi University.
ഞാൻ ആദ്യമായി കോളേജിൽ പോകുമ്പോൾ ഭാവിയെക്കുറിച്ചുള്ള ആശങ്ക പലതായിരുന്നു. എന്നാൽ സുന്ദരമായ ആ ക്യാമ്പസിലേക്ക് കയറി ചെല്ലുമ്പോൾ ഒരു ആത്മവിശ്വാസം എനിക്ക് ലഭിച്ചു. നല്ല സുഹൃത്തുക്കൾ, സംശയമകറ്റി വെളിച്ചം പകർന്നു തന്ന അധ്യാപകർ, പുതിയ ആശയങ്ങൾ നൽകിയ ലൈബ്രറി, ഏകാഗ്രതയും നല്ല ഓർമ്മകളും നൽകിയ ക്ലാസ് റൂമുകൾ, ഡിജിറ്റൽ ലോകത്തേക്ക് പറക്കാൻ പഠിപ്പിച്ച കമ്പ്യൂട്ടർ ലാബ്. അങ്ങനെ MES കോളേജ് എന്നെ ഉയരങ്ങളിലേക്ക് സ്വപ്നം കാണുവാൻ പഠിപ്പിച്ചു. ഇന്ന് ഞാൻ വളരെ ഹാപ്പിയാണ്. സ്വപ്നങ്ങളെ പിന്നിലാക്കി ഉയരങ്ങളിലേക്ക് ഞാൻ പറന്നുകൊണ്ടിരിക്കുന്നു. യു ഹാവ് ടു ഡ്രീം ബിഫോർ യുവർ ഡ്രീംസ് ക്യാൻ കം ട്രൂ.
MES College Erumely, proposed PO Erumely, Kottayam, unaided arts and science college under the Muslim Educational Society, approved by Government of Kerala and affiliated to the Mahatma Gandhi University.
Dear participants, all of you please stay with us. The webinar will continue after 5 minutes. Hello. Hello?
Okay, welcome back to the webinar, Introduction to Intellectual Property Rights.
Ma'am, your screen is visible.
Oh, just a minute, sir.
Okay,
Just a minute.
okay, no problem, no problem.
I think you can see the slides, right?
Yeah. Yeah, now PPT is visible.
Yes, okay.
Can you please? Yeah, okay.
Okay. I was just, I think I stopped here. So I think I'm audible, right?
Yeah,
So,
audible.
yes. So actually, when we talk of property, we talk of basically this tangible forms of property. We are very familiar with this form of property. This because the house or in which we are living, the car that we are driving, or the ornaments that we use. These are a form of property which we are very aware of. We are also aware of one more thing, and that is, the awareness that these are our own.
Ma'am,
We won't.
ma'am, sorry. Can you
Yes.
change the to presentation view? The slide.
Just a minute. Just a minute.
Oh, okay, okay.
Is it okay?
Yeah.
Is
Yeah,
it
now,
okay now?
yeah, now okay, now okay.
Okay. So the thing is that look, when you're living in your own house, what we find is that we won't allow any other person. We don't like any other person stepping into our house. We don't like, if this is my car, I don't like any other person barging into my car and saying this is mine, because suddenly what happens is that we have a feeling that look, this house is mine, and one fine morning, if you find two or three persons barging into your house and saying that, look, we are going to live in this house from today onwards, you feel so embarrassed. You feel so astonished. What are these people doing here in my house? Because this is my property. And again, if a person comes and just takes the key from you very forcefully and say, look, this car is mine, we will never accept it. The same thing happens in intellectual property rights also. The same form of property, the same attachment that we have towards a property, the same feeling of this is mine, that particular feeling, this happens in intellectual property rights also. So as far as IPR is concerned, the difference between IPR and the tangible forms of property is that, you can see your house, you can see your car, you can see your ornaments, you can see all the vehicles or the land that you have acquired, but you cannot see the intellectual property rights because that is creativity. That's the only difference. The all other rights that is available to the tangible form of property or something which you can touch, and the intangible form of property that is intellectual property rights, it's one and the same. You can possess IPR, you can sell it, you can give it to someone on a voluntary basis, you can lease it out, and you can even destroy it. No issues. So what all you can do with your property, your car, or your house, or your vehicle, or whatever it is, the routine property issues, you can do with the IPR also. So again, you can always consider intellectual property as a bundle of rights. You have a right to occupy the property, you have a right to sell it, you have a right to borrow against it, you have the right to exclude others from it. Look, some scientists, they are very sure, they are going to make the COVID vaccine, they're going to make the COVID drug, they are going to make a drug against the cancer in maybe different forms of cancers. They are going to make a drug against SARS. So look, will they accept your version that the drug is yours? They will never accept it because they have spent years to make this particular drug or vaccine. They have spent a lot of amount of their research, their time, their money, everything into it. So they will never allow any other person to encroach upon their property. So intellectual property rights, it is nothing but a form of property. The only difference is that it is intangible. And what happens is that, tangible property, it excludes rival persons from it. And as far as IP is concerned, it is non-rivalrous and non-excludable. I'll just explain this. Why did I say it is non-rivalrous and non-excludable? The answer is very simple. IPR, once you create an IPR or the different forms of IPR, the only difficulty is in creation, nothing more. It's very difficult to create a new drug. It's very difficult to invent a new vaccine. It's very difficult to draw a picture. It takes time to write a poem, or to produce a film, or to write a novel, or to take a photography, or a wildlife. For example, this year, a Malayali was awarded the Malayali woman. A girl was awarded the Wildlife Photographer Award. So World Wildlife Photographer Award. So it's very difficult to take a photo So it's not very easy, when you see the photos, you find it's very easy, but it's not so. So it takes that time, it takes their energy so that, you bring a new product out of it or a creativity out of it. So once it is created, whether a drug it is created or a sort of vaccine is created or a photo is taken or a picture is taken, whatever it is, it's very difficult to create. But once it is being launched, you can find different persons watching it closely and bringing different forms of that particular drug or that particular photo or a photograph or a painting into the picture into the society. It's very easy to replicate. For example, copies of paintings can be made relatively with little cost. So this is what happens. This is what IPR tries to prevent. Look, we have seen there is a one original version, but different forms of copies circulating among us. So this is what we know. This is what we have found out. So the difficulty in creation, there is difficulty in creating something, but there is no difficulty in replicating the same. When you're replicating an IPR, what you're doing is that you're stealing some other person's property. So when you're stealing some other person's property, the example that I told you, when you barge into another person's house, you will be slapped, that particular person, he will not smile at you, isn't it? What that particular person will do is that, he'll immediately approach the police station and file a criminal complaint against that particular person. So here also what we do is that IPR also will not allow any other person to encroach upon the property, the different forms of property, whether it is patent or copyright or trademarks, trade secrets or geographical indications or traditional knowledge, whatever format it is. So this different forms of IPR, they have laws attached to it. They have the backing of law because patent, it has a Patent Act. The designs, it has the Designs Act. The trademarks, it has the Trademarks Act. The geographical indications, it has the Geographical Indications Act. And the copyright, it has the Copyright Act. So the importance of these laws is that, it tells you what are your rights. It talks about your obligations. It talks about when your rights are being violated, when someone encroaches upon your IPR, that is whether someone has created problems for violated the patent or the copyrights. Now, what is the liability when you're being encroached upon? So all this are being beautifully narrated in all these legislations. So first of all, I'll just explain quickly the different forms of IPR. First of all, patents. Patents, whenever we talk of patents, definitely, I told you examples, simple examples. For example, electric lightning, maybe the plastic. The patents is held by a particular person. The ballpoint pens. These are the simple examples that I'm trying to tell you. The CDS. So all these. So here, as far as patent is concerned, always we relate patent to a new product or process. So that is the importance. It's a new product or a process. So it involves the term invention. So patent, it is always given to a new product or process involving an inventive step and capable of industrial application. There must be invention. It must be new. And there must be an inventive step and it is capable of industrial application. That means it must be in use. Then you are in a position to industrially produce a particular product that you have made. So when you say it is a new product, that means you don't have knowledge about that. It was not in use actually. It is something new. Look, when you see that particular product, you must think, oh, it is unique. It is new. We never have even thought of. Okay, that is the newness. That is the implication of the word new. Okay, invention must be new, and it is the persons from science field. If you have students from science background, if you have participants from science background, what you must do is that if you are engaged in research, if you are doing research in your lab, if you have reached the final stage and you're very sure that your research is going to lead yourself into a new product, whether it is a drug or any other matter, if it is new, please don't publish it. Look, first file your application for patent and then only publish it, because without filing a patent application, what happens is that if you just publish, if you write in some books, or if you write in, maybe if you publish your article in the science magazine, what happens is that when you file a patent application, what the patent office will do is that the examiner, he will go through that particular patent application. And you will find that you have an article. There is an article written. There is something. There is an article written about this particular product. Even though it was written by you, it is of no use because it's already there. Because what I intend to tell you is that patent can be taken only on products which is new. That means the public should not have a prior knowledge of this particular product. So it must not be in public knowledge, or it must not be in prior use in India or in any other country in which you are filing a patent. And it must be very useful. Patent the product that you are inventing, that you have invented, that you have seeking patent. What happens is that it must be very useful. It must be useful to you, because what happens is that if you have invented a product which is not useful to the society, then you will never be granted a patent. You will never be granted a patent. Because if you have invented a guillotine machine, what use does it serve to the society? If you have invented a machine which have the capacity to annihilate number of persons, it works 24/7 without any rest, questioning the laws of motion. Look, is it useful to the society? What is the use in inventing such a product? So invention means, it must be useful to the society. And again, patents, normally it can be taken for drugs or any new products. When you're going for a patent for a drugs, you can take a patent for the drug substance itself. You can take patent for the chemical composition. You can use patent for the method of use. That means how that drug is being used to treat a particular condition. So you can use patent for that. You can take patent for the formulation of that particular drug, the physical form of a drug, and a method of administration, and the process of making it, the manufacturing methods. So what happens is that the drug, the substance of you can take a patent on the chemical composition, the method, the formulation, and the process of it. Now, there are certain areas in which you will not be given patent. For example, when you're saying you're going to invent a perpetual machine, when you're going to say that you are inventing a device which is capable of housebreaking, okay, you're inventing a machine which challenges the Newton's laws. You are discovering a microorganism. I emphasize the word discovery, because microorganism is already there in the nature. Have you invented a microorganism? No. If you have invented one, if you have invented a laboratory replica of that, okay, fine. But if you have invented a microorganism, then you won't be given a patent. For example, in the famous case of BRCA1 and BRCA2, where the scientists, they were trying to understand the gene which causes breast cancer. So they located it, and they claimed patent for that. But the court stated, look, what have you done? Have you invented something new? What you have done is, you have located something which is already there in the nature. So we cannot give you patent for that. So look, discovery of a microorganism, it does not amount to a patent. Then discovery of a natural gas, and then you try to combine two products which is already there, and you say it is a new product. Again, you will not be given a patent. So there are areas in which you won't be given patent, and then the term of patent is 20 years. So if you have invented something new, a product, you're eligible for patent, and this patent is for 20 whole years. 20 years, it is years, but years in sense, please don't take it in an extreme format. You're being protected. Your right is being protected for 20 years. After that, you can decide, you can sell it, you can license it, you can lease it out, you can franchise it, you can do, but the fact is that, it's 20 years. After 20 years, it goes to the society, it goes to the public domain. Okay. So the fact is that if you are trying to do something which is quite unreasonable, then the law will try to law will intervene, and law will try to question your arbitrary activities. I'll just tell you an example. A drug was being patented, and it was being used for patients who were actually for liver cancer and for kidney cancer. Okay, for liver cancer it is being used. A drug it was invented. Now the drug claimed that it is not a magical drug, but your lifespan it can be increased to a couple of years can be increased. That is that claim, and actually it was a very effective drug also. But the owners of that patent, what they did was that, they charged the price of drug, they stamped the price of drug to about 3 lakhs. Okay. So it was quite unreasonable. It was beyond the reach of the society. It was beyond the reach of the people. So you are blocking the access of the society to a new product. Look, actually, why did you make the product? It is for the society. Look, every IPR, it has a social justice background. It has to ensure social justice. It is for the society that we are creating new products. But if you create barriers to the access to that particular product, what happens is that the law will interfere in the form of compulsory licenses. And the law will say that, look, your activity, your action is not good. So you have to reduce. We will issue compulsory licenses. We will ask some other person who has a capacity to provide this particular product with a lesser in a lesser range, in a lesser amount. So we will do that. So that is nothing but the compulsory license. So again, you can file a patent application, and you will also be granted time to complete. You can file. Look, for example, if you are very sure that your research is nearing completion, you will arrive at your research will be successful. You can file a patent application. There is no problem. You will also be granted time to file the complete patent applications. Now, if any person has objections towards this patent, the patent application, he can file a pre-grant opposition. And even after you're being given patent, if a person can oppose the patent that is being granted to you. Okay, and then the patent examiner goes through your patent application. If it is new, if it is actually it is not in existence, if it doesn't fall within all the prohibited areas of patent, definitely you will be granted patent. And definitely what happens is that once you are being given a patent, you can have a patent for 20 long years, and then after that it goes to the public. So the examples of patent, this is also a form of this is a very simple example that we often share it with the students especially. Look, the ring pull cans of Coke. Actually, this is a patented one. The ring pull cans. So it is a patented one. The inventor license a system to Coca-Cola. The person invented this, and he licensed the system to Coke. And you can understand. You can. And he also charged a rate per can. And during the period of validity of the patent, the inventor obtained 1,48,000 UK pounds a day as royalty. So patent also has something, it can make your purses shine also. So this is one example of patent, the implications or the benefits of patents. So now the second form, trade secrets. So it's 4:30, the right time for you to understand the rudiments of trade secrets, because you will be sipping your coffee or tea. So what is trade secret? It is a formula, pattern, or device or compilation of information. So it is used in one's business. Okay, it gives commercial knowledge, and it is not generally known. Still now you don't know what makes this Coke so tasty, and you don't know the recipe or the ingredients of KFC chicken. You don't know the ingredients of KFC chicken also. So all these are trade secrets. And what happens is that, this IPR is basically, it does not have a term. When I told patents, it is for 20 years. Trade secrets, it is not for a particular term. It is the only condition that is being talked for trade secrets is that it must be used in business. You must be in a business, you must be running a business, and it gives a commercial advantage. Look, don't think that it is always related to food recipes. It can be the data, the data of your consumers. If you are running a big a showroom, for example, if you're running an MNC, if you're running a supermarket, your consumer list is also your trade secret. So look, the formula, pattern, device, or compilation of information which is secretly kept, that is a trade secret which is secretly kept, which is not shared with anyone, and it's very confidential. That is trade secret. So the essentials, it must be secret, it must have commercial value, and the holder, that is the person who holds it, must have taken reasonable steps to keep it secret. You can understand this because, if you don't know the recipe of Coke, if we don't know the recipe of KFC, that means the holder has taken every reasonable steps to keep it as a secret. So that makes it the IPR. So again, for example, there are different case studies. For example, this case study which talks about how the confidentiality agreement was violated, and what happened thereafter. So now coming to the third one, the copyright. So I've mentioned about the patents, I've mentioned about trade secrets. Now what is copyright? Copyright is a right given to a creator. Creator means what? Creator of a literary or artistic works. Look, copyright, it includes books, newspapers, computer programs, databases, films, musical compositions, choreography, paintings, drawings, photographs, sculpture, architecture, advertisement, maps, and technical drawings. All this, if you have created something, if you have written a book, if you have made a computer program, if you have produced a film, if you have undertaken a musical composition, your dance performance, everything, it falls within the literary and artistic work. And again, that is nothing but copyright. So, copyright, one of the basic characteristics of copyright, it is a combination. It contains a lot of rights. It's a bundle of rights rather. You have the economic rights. For example, in the copyright, you have the right to reproduce or make copies. Okay, you have the right to reproduce the novel or the book that you have written, reproduce or make copies, distribute to the public, sell it, rent it, lease it, license it, display or perform to the public, adapt and translate it, for example, derivative work. So it's a bundle of economic rights. And the moral rights. Moral rights means copyright contains moral rights. That means right of paternity. Look, if you are using some person's photograph, if you are using some person's poem, if you are using some person's musical note, especially, if you are many youngsters, many students, you are, extensively using Instagram, right? Instagram, and then you are updating your WhatsApp status. Look, if you are using another person's musical note or a picture or something of that sort, you have to acknowledge it. Right of paternity is there. Right of integrity is there. Look, the owner, the person, the copyright holder, he has the right to object against mutilation or distortion of work. So right of integrity is there. So moral rights cannot be transferred, it can be waived. OMR ഓട് വെക്കും. So copyright, it may be films, it may be the literary, that is the books that you have written, it may be dramatic performances, sound recordings, artistic creativity or music, everything, whatever new that you have created, it falls within the realm of copyright. So again, there are three kinds of when I talk about performers' rights, there are three kinds of related rights. For example, right of performers. For example, the actors, the musicians, the singers, the dancers, or generally people who perform their performances, all of them have copyright attached to them. Then rights of producers of sound recordings, also called phonograms, in their recordings, cassette recording, compact disc, etc. You have copyright attached to that. Then rights of broadcasting organizations, in their radio, television programs, and in the internet broadcast, you must be very careful because, it comes within the realm of copyright and it is their property. So when as teachers, as students, as researchers, copyright is also very, very important for us because when we do research, when we teach, when we take classes, when we write assignments, copyright also, we must understand the rudiments of copyright also, because very many times the researchers, they ignore the precautions we take. So copyright, a creative writing, if you are taking something from, if you are writing an assignment, okay, if you are taking paragraphs, if you're just copying paragraphs from a book or an article, you are creating problems for the original copyright holder. Okay, so researchers and writers, they play a double role in their academic exercises as both creators and owners and users of copyrights. So, as creators and as users, we have certain rights and duties and responsibilities. But what we have done, whatever we have created, whether it is a form of a book or a poem, it comes within to the society. And those persons who are using them, they also have certain duties and responsibilities. So it's very important to protect the rights of the creators of copyright, that is the author of that particular format. So it must be very important to protect the rights. So copyright system actually, it basically revolves around two theories. First one, the fairness theory. The second one, the welfare theory. Now the fairness theory, it is very author-centric. It promotes the right of authors by giving them exclusive opportunity to profit from their work. Now, welfare theory, it focuses on the interests of the society. So the work created by the authors must be made available to the society for the greater public interest. So the authors, while they have right to benefit from their work of labor and creativity, also have a duty towards society, that is dissemination of knowledge. Look, when you have written a book, it is well and good that you have written a book, maybe, but it is your property also. You are the author of that particular book. But again, what happens is that, look, you must share it to the society. You must give it to the society. So what happens is that, so copyright always plays a balance between these two. It tries to balance the rights of the authors. It also tries to balance the right of the society also. Okay, so a fair balancing is actually seen in almost all copyright laws. Okay. So that is why we use the term, we give certain exceptions to copyright. When I was talking about patent, I told about certain prohibited areas where patent is not being given. But again, when I told copyright, the author is given the privilege and he is given the prior importance. He is given the most important standard, most important priority. But again, copyright also uses the term fair use. Both the authors and the readers, we have to understand what exactly is fair use. So fair use means, look, as students, as researchers, we might be doing research writing, we may be doing book writing, textbook, reference books, etc., essay writing, article or journal writing, report writing, project writing, or review writing, including books and article reviews, review of literature survey writing, etc. So what happens is that as creators of copyright material or writers, the members of the academic or research committee need to be very careful, because when we try to encroach upon another person's property, you must be very careful. No work is made up of vacuum. The academic works are actually the labor of some persons. These works are copyrighted. So when we use the copyrighted work, it must be for academic purposes. So why have you given copyright to them? We have given copyright to them as a reward for their creativity. At the same time, we also have to ensure that whatever they have been created is also given to the society. The society gets benefit out of it. So that is why, because you cannot say that, the author should decide everything. That will be nothing but monopoly. So we cannot encourage monopoly. So we must encourage the interest of the society also. So the fairness theory of a copyright is based on the premise that law definitely has to protect the authors. At the same time, they have to recognize the fruits of their labor, but they also have to give opportunity to the society. So all works, they are not copyrightable. For example, only those works which have a minimal degree of creativity will be given copyright protection. So when I talk about exceptions to copyright, when can you create a little bit of dent into the author's right? We have section 52, which talks about fair use or fair dealing for research. Okay, so says that there are certain exceptions to the exclusive right that is being given to the copyright owners. So fair dealing means, or the fair use, which says that, if you are using the copyrighted works for research and academic purposes, the fair dealing doctrine, it says that if you're using your copyrighted works for research and academic purposes, then you're eligible to use the copyrighted works. Okay, so however, you can only use a portion of that particular work. It doesn't mean that you can use the entire material as your own. It's not so. Article 52, section 52 says it is fair use. So no substantial, I use the term fair use, but I've never used the term copying. No substantial copying would justify a fair dealing. So substantial copying and material reproduction amounts to copyright. So you can only use a insubstantial portion, and again without seeking the permission of the copyright owner, you can only use an insubstantial portion. Now what is insubstantial? It is purely a qualitative question. So the larger the copying, the less the fair is the dealing. And again, if it is not academically fair and ethical to copy massively from another's work and justify it as a fair use. So what are the tests that has been talked about? We have different formats to examine whether it is fair use or whether it is nothing but typical copying. First, you have the permissible purpose test. Then we have for example, it is stated that what is the purpose of using another person's copyright, what is the character of the dealing, the amount of dealing, the alternatives to the dealing, then the nature of the work, the effect of the work, etc. You have to go through and then decide. Then again, for example, if you are photocopying academic materials and photocopying it only for academic purpose, then it is authorized under law. Even in India, we had one particular case. For example, in Delhi University, what they did was that, the publishers, the OUP, the Oxford University Press and the Cambridge University Press, they told that, Delhi University had a habit of giving course packs to the students. So what they did was that they took photocopies from different references books, and they made a course pack and they gave it to they distributed to the students. And what happened was that look, the publishing house stated that, look, you are taking, you're photocopying our property, our work, and we will not allow this. And they filed a suit against the Delhi University. And ultimately, the court stated that, look, what Delhi University was doing is nothing but an academic service. They compiled extracts and only to make it available to the students, and so there is no copyright infringement. So very often we find that the publishing houses they take a different stand, stating that look, they are encroaching upon our property. For example, making course packs, it is nothing but you are intruding upon our property. All those contentions are being made by the owners of the property. So generally, 4 factors are being taken to decide what is a fair use. First of all, we look into the purpose and character of the use, whether it is for educational purpose or it is for a critique. Then again, the nature of the copyrighted work, whether the work is eligible for copyright. Third one, the substantiality of the portion used in relation to the copyright work, the extent and nature of copying done. For example, I've already told you, if you're writing an article, if you're writing an assignment, you have copied verbatim from one particular book itself, then that is nothing but copying and it is not a fair use. And then effect on the potential market or the value of the copyrighted work. Whether the new work that you have created adversely affects the market value of the original work. So the qualitative and the quantitative test is also being applied. Look, for example, I've already told you, if you are verbatim copying, what you have done, you have taken the heart of the book. So when you take away the heart of the book, it is nothing but copy. Okay. And verbatim lifting, it is crystal clear that it is nothing but infringement. So you cannot use the term fair. It is a fair use, but it is only violation of copyright. For example, you verbatim copy several extracts from the Cambridge University publication. You take the exercise, you take the answers, you take the placement topics. Then it is nothing but copying. So you will never get the exceptions or the protections that is being given to the exceptions. So what we should do is that we should avoid plagiarism at any cost. So what copyright allows you is fair use for research purposes, but all other things is nothing but plagiarism, and you are creating problems for the copyright owner. So all the researchers who are listening this, we have a duty to respect the moral rights of the author under section 57 of the copyright. And these rights, it is inalienable. It is always there with the author. Now, trademarks. Trademarks is another form of IPR. It is the value of it. It is nothing but it gives the value of a business assets. All these formats, for example, the Coke, the manner in which it is written, the Microsoft, the IBM. How it is being written, how it is being picturized. All this. It is nothing but trademark. So. It gives the identity to the global brands. So that is the characteristics of trademark. So trademarks can come in different formats. It may be a name, it may be a logo type, it may be a symbol, it may be a slogan, for example, I am loving it. It may be a shape, for example, this particular shape, the M of McDonald's. It may be a color. Okay, so the trademarks, it can come in different formats. and you have different trademarks across. Just look at this. Look at this slide. You have umpteen number of trademarks. For example, Oral B, Tropicana, Walmart. So all these, the Swiss Air, all these are trademarks. So what is the benefits of trademarks? So trademarks, I told you it is the identity. When you have identity, what happens is that you are assured that this comes from a particular source. The quality is being assured, and then what happens is that you have also different choices. So the knowledge is there, the esteem is there, the relevance is there, and differentiation is there. How different are two products? Because you have different computers, you have different PCs, you have different labs, but you have different trademarks to differentiate them. So this is the importance of trademarks. So again, you have the brand companies also. So trademarks, what happens is that when we talk of trademarks, naturally the tendency is that when a person is using a trademark, when he has established himself in the society, what normally others do is that we try to go for the easy route. Look, for example, Godrej. Godrej is a company. It sells almaras. It supplies you furnitures, etc. So we know how the trademark of Godrej also. But at times we come across products which is like Godrej. If you just watch carefully, you can find the R missing, or you can find the D missing. But on a first look, you feel, yes, it is from Godrej. So what is the aim of this? That means trademark is being taken by Godrej, but some other person also uses a similar one so that you can create confusion in the society. You can make the society feel that, this furniture piece is from Godrej. So that means, or I've used one particular example. You have a very famous, well-known fashion brand which is called Zara. Zara, it's a trade. They have taken a trademark also. And what they did was that a restaurant was opened in the name of Zara. What will we think? Look, Zara has opened a subunit, and this restaurant is also a part and parcel of Zara. So this is what typically the people do. This is what we call infringement of trademark. For example, Bata. We are aware of the shoemaker company Bata. But another company, one fine morning, they started a company and they began to market foam materials using the name Bata. What will we assume? We will assume that, this is from the same shoemaker company Bata. So how the the Bata company, they filed an infringement case against the second company. The judge asked a very normal question: how would the consumers know that the Bata is not producing foam? The judge reasoned that it is reasonable for any person to assume that this is a product from Bata. And again, London Dairy versus London Dairy. On a first look, there is no difference, not even in the pronunciation. And we will also think it is from the same, this is one and the same. So this is how what happens is people try to deceive, people try to create confusions by using the trademark of some other persons. Now, when we talk of trademarks, when in the case of infringement, what happens is that, look, you can stop such infringements. You can file a complaint in a civil court, and the civil court, they will grant injunctions. They will ask to stop the practice of using the trademark of another company. And again, when I'm talking about trademarks, we must also be aware there are non-conventional marks also. For example, trademarks can be taken for color. For example, the purple color of Cadbury's, it is a trademarked one. You can take for trademarks for shape, for sounds, for scent, for taste, etc. For example, the Yahoo Yodel, the Zippo lighter, the sound mark of Alliance, the sound mark of ICICI Bank. All these also forms of trademarks. So these are called non-conventional trademarks. But the only thing is that, as far as in the case of non-conventional trademarks, the only difficulty is that, when you're applying for a trademark, you cannot use letters or numbers or logos or symbols to describe this. So it creates a little bit of difficulty as far as how you can depict all this. Okay, so that is a difficulty that has been attached to non-conventional trademarks. But you can go for sound, color, and even for taste also you can go for trademarks. So of late, order marks, they have also gained popularity. Sound mark has also been have taken acquired popularity. Color mark is also there, and the scent mark is also there. So now coming to the industrial designs, I told you designs is also forms within the realm of IPR. So designs is something which you use to make your product appealing to the consumers. So this falls within the ambit of IPR. Now, geographical indications, I told you there are certain products which belongs to a particular area, for example, Kani shawl of Jammu and Kashmir, then Madhubani paintings of Bihar, then you have the Pochumpalli saris of or Ikat of Andhra Pradesh, then the Kanchipuram silk, the Aramula Kannadi, Mysore silk, Chanderi fabric, everything, it always locate to a particular area, particular environment, and a particular group of people who know how to make this particular product. Okay, or how to nurture this particular product. For example, Nagpur oranges, apples from Kashmir. So, it is only available there. The tea from Nilgiris. So, all this, it is geographical indications. This is also an IPR. It was not an IPR because, when we just go through patents, copyrights or trademarks, you find creativity in it. But when we talk of apple, when we talk of oranges, when we talk of the other forms of flora and fauna relating to one particular area, it doesn't have a creativity. But definitely, the Pochumpalli silk or Kanchipuram sari does have creativity in it. So, but the peculiarity is that, these products, they arise from one particular product. So, maybe cheese, the olive oil, the tea that is Darjeeling, which is grown in India, the wines and the Scotch whiskey from Scotland, all these are geographical indications, and the stakeholders involved in the geographical indications, they are being protected, and other persons, they cannot involve in this particular geographical indications. And again, you also have, but again, what happens is that, at times you have complicated cases. For example, we have an issue of Tirupati Laddu claiming geographical indications. We have Hyderabadi Hallam, a combination of mutton stew, claiming geographical indications, which is being brought before the court of law. Now, the last IPR, which I really want to share it with you, is traditional knowledge. Traditional knowledge, for example, our Geethangal, our Vadyopakarnangal, for example, Chenda, the Pulluva Veena that we are familiar with, the martial arts that are Kalari, then the verbal arts, then verbal expressions, then the pujas. then the Anushtana Kalagal, for example, Teyyam, Tira, Tiyata, Krishnanatam, then the Anushtanangal, for example, Totem Pata, Puluvan Pata, the Tea Pata, then Kshetra Kalas that we are also familiar with, for example, Panchavadyam, Chandamelam, Tayambaga, then rituals. Then the entertainments, Kolkali, Mudiyatam, all these, all these comes within traditional knowledge. And again, the traditional knowledge also consists of the traditional knowledge relating to, for example, turmeric, the medicinal, we know the medicinal values that has been attached to turmeric, so that falls within the traditional knowledge. We know the medicinal values of neem. Okay, so it is there, it is in the society, we know this, and this again, this is also considered as an IPR. So why are we more concerned about traditional knowledge? I'll just give you an example. I've shown you a picture, and that is nothing but the rosy periwinkle blossoms. So in 1950, Eli Lilly, the company Eli Lilly, they began research in this rosy blossoms. And actually, this was there in Madagascar. It was there it is found in here also, in Kerala also, very very familiar flower. But in Madagascar, it was there. And this scientists from Eli Lilly, they went there. They stayed with the indigenous communities, and they understood the medicinal value of rosy periwinkle. They understood the medicinal values. They came back, because for indigenous people, the knowledge is, they never hoard knowledge. They never consider the knowledge as private. They told the researchers who came and stayed with them the medicinal properties of this particular flower, and the scientists, what they did was that, they understood it, and they went back to the laboratories. They understood the intricacies of these traditional knowledge, and they created a new product out of this. Look how our traditional knowledge is being transformed into a product. They isolated 2 extracts, and they made 2 drugs, and they patented that particular drugs. Okay, and they never gave a bit of their profit to the indigenous communities. They never shared their benefits from these patents to the indigenous communities. Look, they took the knowledge, which was a public one, they worked on it, they converted it into patent, and then what they did was that, look, they minted money from it, but they never shared anything with the indigenous people. So that is why we are concerned with traditional knowledge, because we must be very careful. For example, our neem, our turmeric, it was being patented, and we use the term biopiracy for that. And then we could stop these biopiracy, because we have documented many of our traditional knowledge. So again, traditional knowledge is also a form of IPR. And the last one, that is the plant varieties. So we talk of creating new plant varieties for agriculture, horticulture, and forestry. And definitely, this is also a form of IPR. And now, what happens is that, yes, I've covered the slide. So I started my interactive lecture by stating that IPR definitely, it is for the society. It is for the society that we are talking about IPRs. We must definitely, the concept is that, it is a property. It belongs to the patent holder. It belongs to the copyright holder. It belongs to the trademark holder. Definitely, it belongs to the holders. But the fact is that ultimately it is for the society. You're inventing a product for the society, you're writing a book for the society. All those, the societal public interest must be there in your mind. Otherwise, the whole purpose of IPR will not serve. Look, if you are inventing something only for your gain, and it is not for the society, it doesn't make much improvement. So IPR, it's one of the fascinating areas of science, technology, biotechnology, biosciences, law, medicine, etc. And definitely it keeps on changing because we add a lot of IPRs into the list, so it's ever changing. But what we should remember, what we should keep in mind is that the societal interest is always the most important thing. The social justice part is the most important thing. Thank you. Sorry for the technical hitches that happened in between because I was traveling from Trivandrum to Kottayam. I couldn't reach Kottayam on time, so that is why a little bit of technical problems arose in between. Thank you.
Shiba ma'am. Jasila ma'am.
Hello. Hello, can
Yes, Shiba ma'am.
okay, sir. Good evening. Madam.
Yes, ma'am.
Okay, madam. It's very nice presentation and very informative and presenting to the audience, madam. And there are some queries from our audience.
Yes, ma'am. Yes, ma'am.
Please differentiate between the company name and trademark, madam.
Trademark, ma'am, it goes within the IPR realm. If you want to have a trademark, you have to first, you have to go through the formalities. You can have a name, but again, if you want to have the TM attached to it, okay, you should go through that particular process of taking the trademark. You have to file an application, you have to remit the registration fees, and again, your trademark must be unique. For example, I'll tell you one example. Look, you have seen different sorts of arias, isn't it? For example, when you're just traveling from Trivandrum to Thrissur or Trivandrum to Ernakulam, you can find different arias. You can find arias, you can find new arias, you can find arias in different letters, in different spellings. Actually, we don't know which one is the real one. So this is what the trademarks tries to stop. Trademarks, if you have taken trademark, the original holder, he can stop any other person from using the trademark. Look, the company name, it won't have that particular protection of trademark. The trademarks gives you protection from infringement. It will grant you injunction from infringements. And what happens is that, you will have the assurance, you will have the law to protect you.
Okay, madam. Can the one audience asked, can I register a slogan as a trademark?
Yes, even in the slide, I've given that, you can use slogans, but provided it will not create problems for the public order. It is not a slogan which is used by the governmental sector. For example, it is not being used by the UN or the international organizations or the organizations of that sort. So you can use it. You can use expressions. You can use combinations. You can use phrases. Everything you can use it. But the only exception is that ma'am, you should not create problems for the public order, security, etc. So the examiners, what they do is that they just go through whether it has the potential to create problems for the society. If so, then they will never grant the trademark logo to trademark protection to this. But otherwise, it's fine, no issues. I think I've given an example in one of my slides. An example.
And another one asked that are all goods be protected by registered trademark?
Pardon?
Are all goods be protected by registered trademark? Yeah.
Are our goods?
Okay,
I didn't get the question.
Okay, madam, no problem. Then another one asked, who can apply for a trademark registration? Who can apply for a trademark registration?
Any person can apply for a trademark, but normally what happens is that if you normally what persons do is that look, if you have started a company, or if you have normally you go for a trademark, isn't it? If you have started a restaurant business, you go for a trademark. So normally such persons goes for a trademark. Otherwise, you'll be hired by persons to create a trademark. That is a different story. But normally persons who are in commercial enterprises, they will go for trademarks. Because I told you, you have different laptops. But why are you going for a trademark? Because in order to make sure that you understand the identity of that particular source. That is why.
Okay, madam. And one of them asked, how much time it takes to grant patent in our country?
Basically, that's that's a very good question. The fact is that you must grant patent as soon as possible. That is what the act says. But ma'am, what happens is that normally it takes a little bit of time, maybe from 6 months to 2 years. It takes time because there was a shortage of examiners, patent examiners. When you file a patent application, it has to be examined by a patent examiner. You can find patent office in 4 different jurisdictions in India: Chennai, Bombay, Calcutta, 4 different jurisdictions. And for those persons who are residing in southern part of India, we have to file it in Chennai. So our applications, it will be examined by the patent examiner. And if you don't have adequate number of patent examiners, there will be delay in granting patents to you. So this actually happened, and now the government, they have rectified this. They have appointed number of patent examiners. So if you have adequate number of patent examiners, definitely there will not be any delay in granting patents and processing your patent applications. But normally it will take 6 months to 2 years. Because when you're just for example, if you're just going to any shop to buy a mask, for example, the mask of Biotic. Biotic mask, the face mask, it uses a combination of neem, tulsi, and certain other herbal plants. And they have their claim is that it is purely herbal, and again it refreshes the air that we take. There are certain claims for that, and in the mask, in the packet, you can find patent pending. Patent application pending. You can find that. So many of you have come across that also.
Okay, madam. Then another one asked that how can I get a patent for a new invention like an Ayurvedic medicine?
As far as the Ayurveda is concerned, it's a very tricky question, because Ayurveda, definitely in the Patent Act, it talks about Ayurveda. But one difficulty as far as Ayurveda is concerned is newness of Ayurveda. How can you prove it is new? novelty, you have to assure novelty for your product. So there is nothing wrong in taking patents for Ayurveda. It has been accepted. Only thing is that the product or the drug that you make is new and it is useful to the society. If so, there is no problem as far as taking patents for Ayurvedic medicine. But it actually, it's very, the question is being asked because, maybe the person is from that Ayurvedic field itself. That is why he or she has asked that particular question, because actually, as far as Ayurveda is concerned, the base knowledge is known to the society. Very many of the base knowledge is known to the society. At times, there may be problem as far as the newness is concerned. But again, you can sidestep this by, don't go for admixture of combinations, admixture of drugs that is known. So you just go for a new one. Then definitely you can go for a patent.
Okay, madam. Thank you very much. I think the questions are over. Shall we wind up?
Yes, ma'am. Thank you. And I'm extremely sorry for the 10 minutes hitch from my side because, I had no other option. Otherwise, I had to continue the interaction from my car itself. I'm so sorry for that.
No, thank you, madam, very much.
Thank you.
For a formal note of thanks, may I invite our CDC Director, Kavita PD? Kavita PD, over to you.
Okay, thank you, ma'am. Good afternoon, all. Let's remember this fabulous afternoon with enlightening thoughts and ideas. It's truly a glorious occasion for us to be with such an eminent personality. I hope this webinar is truly a blessing for every participant because Bismi ma'am simply explained to us what is IPR. Here, my duty is to extend my thanks to various personalities present here. First and foremost, our principal, Mr. Mahiniaman sir, is really a great man with a lot of splendid ideas. It's here he is the backbone of the series of webinars conducted in our college. On this occasion, I extended my sincere thanks to our honorable principal. Thank you, sir.
Thank you.
It is great skill for a person to convey her knowledge to other people completely. Our resource person is truly such a gifted personality. I wholeheartedly thank Dr. Bismi Gopalakrishnan ma'am, Dean, Faculty of Law, Professor and Head, School of Indian Legal Thoughts, NG University, for this memorable section. Thank you, ma'am.
Thank you, ma'am. Thanks a lot.
Then, nothing is possible without effective execution. We have two able personalities with us who successfully coordinate all the webinars conducted in our college. I thank Mrs. Mahadevi M. Madam, Vice Principal and IPC Coordinator, and Mr. Jidesh K. Sir, Vice Principal, Training and Academic 2, for their valuable support and guidance. Then, I extended my sincere thanks to Mrs. Jasila Hanifa, Coordinator, IPS Cell. She is the important person behind the organization of the successful webinar, and also Ms. Shirley Jacob, Assistant Coordinator, IPS Cell. Thank you both of you, ma'am. And I express my gratitude to Mrs. Sheba Michael, Student Dean, for her inevitable presence and cooperation. Thank you, ma'am. I also extend my sincere thanks to Mr. Satan Yusuf, Director, IT Cell, for the technical support. Thank you, sir. Last but not least, dear participants and faculty members, your presence and support is the real source of the success of this webinar. I thank each and every one of you for this wonderful section. Thank you very much.
Last national anthem.
Hello. Okay. We can stay for the national anthem.
അല്ല വേണ്ട സാറേ, അത് വേണ്ട സാറേ. ആ ഞാൻ ഇതും കൂടെ ഒന്ന് പ്ലേ ചെയ്തോട്ടെ.
ഞാൻ ആദ്യമായി കോളേജിൽ പോകുമ്പോൾ ഭാവിയെക്കുറിച്ചുള്ള ആശങ്ക പലതായിരുന്നു. എന്നാൽ സുന്ദരമായ ആ ക്യാമ്പസിലേക്ക് കയറി ചെല്ലുമ്പോൾ ഒരു ആത്മവിശ്വാസം എനിക്ക് ലഭിച്ചു. നല്ല സുഹൃത്തുക്കൾ, സംശയമകറ്റി വെളിച്ചം പകർന്നു തന്ന അധ്യാപകർ, പുതിയ ആശയങ്ങൾ നൽകിയ ലൈബ്രറി, ഏകാഗ്രതയും നല്ല ഓർമ്മകളും നൽകിയ ക്ലാസ് റൂമുകൾ, ഡിജിറ്റൽ ലോകത്തേക്ക് പറക്കാൻ പഠിപ്പിച്ച കമ്പ്യൂട്ടർ ലാബ്. അങ്ങനെ MES കോളേജ് എന്നെ ഉയരങ്ങളിലേക്ക് സ്വപ്നം കാണുവാൻ പഠിപ്പിച്ചു. ഇന്ന് ഞാൻ വളരെ ഹാപ്പിയാണ്. സ്വപ്നങ്ങളെ പിന്നിലാക്കി ഉയരങ്ങളിലേക്ക് ഞാൻ പറന്നുകൊണ്ടിരിക്കുന്നു. You have to dream before your dreams can come true.
MES College Erumely, proposed PO Erumely, Kottayam, unaided arts and science college under the Muslim Educational Society, approved by Government of Kerala and affiliated to the Mahatma Gandhi University.